If you're a small business owner, you may have heard of the Corporate Transparency Act, or the CTA, and thought to yourself, that's just another federal law that applies to big corporations, but not to my small business. Unfortunately, if that's your understanding, it's time to think again. Unlike many federal laws, which apply only to businesses of a certain number of employees or a certain amount of revenue, the CTA applies to most small to mid-sized businesses, even one-person businesses. There's no need to panic. While the CTA took effect on January 1st, 2024, you have time to comply, and I'll help walk you through it. I'm Zana Tomich of Dalton Tomich, a Michigan-based law firm, and I specialize in serving the needs of small to mid-sized companies. In this video, I'm going to briefly explain what the CTA is and who it applies to, what's required to comply, and the consequences of non-compliance. Let's get started. The CTA is a reporting requirement that allows the Financial Crime Enforcement Network, or FinCEN, to gather information about reporting companies, beneficial owners, and company applicants. The CTA's primary purpose is to assist FinCEN with pursuing financial crimes. Reporting companies created or registered prior to January 1st, 2024 must complete an initial report with FinCEN before January 1st, 2025. Entities formed or registered in 2024 will have 90 calendar days from the date of formation or registration to file the initial BOI report. Reporting companies include all corporations, limited liability companies, and other entities formed by filing a document with the Secretary of State or similar office under state law or Indian tribe, or formed in a foreign country and registered to do business in the US. In other words, the CTA applies to virtually all business entities, even the smallest businesses. The CTA contains 23 exemptions. Unfortunately, most of them apply to large businesses, including banks and insurance companies. Most small businesses are not exempt. So what's required to comply? The CTA requires reporting companies to report the following three categories of information. One, reporting company information. This is information that identifies key information about your business entity, such as its full legal name and tax ID number. Two, beneficial ownership information. This identifies beneficial owners of the business, including those who directly or indirectly, A, exercise substantial control over the reporting company, or B, own or control 25% or more of the ownership interests of the reporting company. And three, company applicant information. This is information about the person who directly files the formation or registration document of the reporting company and the person who is primarily responsible for the directing or controlling the filing. Finally, I'll address the risks of noncompliance. Those who willfully fail to report, fail to update reports, willfully submit or attempt to provide false or fraudulent reports, cause the failure to file a required report, or were a senior officer at the time of the failure to file may face civil and/or criminal penalties, including civil fines of $500 per day for each day a violation continues, and criminal penalties including imprisonment for up to 2 years and/or fines of up to $10,000 per violation. So it's important to understand that what I've shared is a brief overview of the CTA's requirements, but there's more to know. While the CTA is a complex federal law and the risks of failing to comply are serious, there's no need to panic. Remember, the deadline for businesses already in existence at the start of the year is January 1st, 2025. That said, it's important to get things done right and not delay. At Dalton Tomich, we're here to help. We can guide you and your business through the CTA requirements and filing process. Please reach out to us if you require assistance.